see you.
Good to see you.
Doing well?
Doing well yourself?
Good. Well, welcome back.
Well, thank you. It's been
Travel-
a while,
travel
actually,
okay?
yeah. Oh, yeah. Just leave early and, not deal with the stress of fearing I'm going to be late.
Good. Feeling better?
Oh, yeah, absolutely. Really appreciate you all,
Of course.
Hey, Judge.
Good. How are you doing?
Good to see you,
sir.
Ray Wilson.
Yes, sir. Good to see you. Yeah. Good to see you. Welcome back. Yeah, it's going great. Welcome back to the court. Look forward to your arguments today. Anything else we need to be aware of before we? Okay. All right. Awesome. Morning.
All rise. The Honorables, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes, the Court of Appeals is now in session. God save the state and this honorable court. Be seated.
Well, good morning.
Thank you and welcome to the North Carolina Court of Appeals. We have one case on for oral argument this morning. It was continued from a prior session. 23-40 Perryman v. Town of Summerfield. Unless there's any further business to come before the court prior to arguments, we're ready to hear from the appellant.
Judge Hampson, Judge Carpenter, Judge Flood. Good morning. My name is Gavin Reardon. I represent the plaintiff taxpayers, in this case, Teresa Pegram, Perryman, and Danny Nelson. Thank you for allowing us to be here this morning to discuss this case with you. It is truly a privilege and a pleasure to be with you today. Before I get into the substance of my argument, I would like to clarify two things that I think are important. First, contrary to the dust cloud that defendants have attempted to kick up in this case is not in any way about Todd Rotrock. And it's certainly not about whether or not Todd Rotrock gets to get back on the Summerfield Town Council. This case is and has always been about only one thing. Do municipal taxpayers have any legal recourse when municipal officials use public tax dollars for the unconstitutional private purpose of paying a defendant's legal fees in a quo warranto action? That's it. Are the courthouse doors open to taxpayers to do something about this illegal spending? It's not about Todd Rotrock, and that's shown by the three claims in the complaint. The first claim seeks a declaration that the spending to pay for Ms. Laughlin's quo warranto defense fees was illegal and unconstitutional. The second claim sought an injunction to prohibit any future spending for that purpose. The third claim sought to make the town whole again by forcing the law firm that received those funds and the council members in their individual capacities to pay the money back to the town.
And as far as that disgorgement
Yes.
claim, that's that from the law firm defendants, that's sort of the subject of the pending motion, partial motion.
Exactly, Your Honor, and that's where I'm going to with this clarification. There's no claim that would put Todd Rotrock back on the town council, and there's absolutely no claim that would require any finding he deserved to be on it. So it's not about Todd Rotrock. Plaintiff's purpose has been to obtain a determination as to the illegality and unconstitutionality of the spending to prevent similar illegal spending in the future. Which brings me to the second clarification, going to what Judge Hampson just raised, that I'd like to make. While we were preparing for the previously scheduled oral arguments, my clients and I reconsidered the Supreme Court's commentary in Goldston that while equitable remedies may be appropriate regarding illegal and unconstitutional spending, in many cases the simple declaratory adjudication of the illegality of the act complained of is the most assured and effective remedy available. So to that end, as I informed defendants' counsels about 45 days ago, today we only intend to argue on behalf of our first claim, which is the claim for declaratory judgment, that the spending was illegal. To be specific, we will not be arguing in support of any claims against the law firm or the individual defendants in their individual capacities. We will not be arguing for the second claim for injunctive relief, which frankly is probably moot. I doubt they're still paying anything on that anyways. And we're not going to be arguing for the third claim for disgorgement or restitution. This also necessarily means that we will not be arguing in support of any claim brought derivatively on behalf of the town of Summerfield itself. So to that end, Your Honors already have our motion to dismiss the claims against Nelson Mullins. As Your Honors knows, unlike the rules of civil procedure, there is no appellate rule allowing for dismissals or partial dismissals. We were willing to take the same sort of dismissal against the individual defendants in their individual capacities, but we couldn't figure out the mechanics of doing it. So our sole argument is that these plaintiffs have direct standing as taxpayers to sue the town and the council members in their official capacities for a declaration that spending money for a quo warranto defense was illegal and unconstitutional. Having said all that, as a preface, I would invite your questions at any time because I'd like to focus on what's most important to the panel.
So I mean, the posture of this case was 12b-6.
Correct. Yes,
Correct. It was dismissed at 12b-6. You know, I know there's possibly some dispute as to the basis of the trial court granted 12b-6, and what do you contend obviously you contend it was erroneous, but what do you contend was the basis of the Rule 12b-6?
Well, I believe, based on, as I think is obvious from or should be obvious, hopefully obvious, from our initial brief, we believed that it was this 160A, 167A was the basis where the judge walks through this analysis. And also a lack of taxpayer standing, that they hadn't made out their jurisdictional. So those were the only two that the order itself raised. Just as in any motion to dismiss, usually there's a whole myriad of shotgun approach of potential bases, but those weren't brought forward in the order, despite the fact that we asked. And I want to be clear, our request for findings, we haven't alleged that to be an error. Of course, the court's jurisprudence is the judge doesn't have to make findings on a 12b-6. What we were asking was, please make it clear to us so that we understand what the basis is, and so that the Court of Appeals can, so that when I write my brief, I know what I'm addressing. I'm not going to the universe of possibilities of things that could be, but weren't raised. So those were the only two that we saw in the order. Do
you concede that if we were to determine that there was some other basis under de novo review to affirm, an alternative basis to affirm the trial court's order here, that we would have the ability to do that?
Absolutely. It being de novo review, I believe it's unquestionable that the court not only could, but would and should. My only concern in that case is that we believe that if it's something that could have been cured by pleading, that it should be remanded for the trial judge to give us that chance. And one of the reasons is because this is an unusual case. The Quo Act makes an appearance in the statute in our cases like once every 20 years, and it just pops up as an aside. So it's never been addressed. How do you bring one of these cases? What do you need to allege to bring one of these cases? So we recognize that there may be a possibility. This court will say, this is how you allege it, and we haven't alleged what we needed to allege. At the trial court, and this is clear, this is seen in the transcript. It would have been more clear in their briefs, which I didn't put in. I would have had I understood what some of their arguments would have been. But they didn't make any arguments at the trial court that would have pertained to anything we could have alleged. It wasn't a lack of allegations at that time. It was them just saying, as a matter of law, there's no basis for you to get into court. For example, in their brief, they have argued that we were required to allege that there was no adequate state law remedy, that was an element we needed to allege in the complaint. They did not raise that at the trial court. They also didn't raise it in the prior case that they've talked about. Had they done so, we would have just moved for leave to amend on that. It would have been easiest enough for us to just add a sentence saying there's no adequate state law remedy. And in fact, the defendants at that hearing argued that Section 521 is not a state law remedy, that we don't have a private remedy. So if, for example, and to be all candid, I think that's the biggest burden, the biggest issue that I have with our pleadings is that we didn't allege that. So yes, if that were the reason why we failed under 12b-6, then it should be dismissed. We were just asked under the case that we identified, McGeechee, I think, which was unpublished, but that the court has the power to remand it to the judge, for him to look at it again to decide whether or not we get to amend. And there was no question that his with prejudice was because he found it to be futile. It's like all of his analysis was, as a matter of law, you can't state this claim. We would have been seeking to amend within a month or so of the case starting. Does that?
Yeah, thank you.
Having said that, again, because the bases were this 160A and lack of jurisdiction, I'd go to the jurisdiction that our cases, I believe, actually they're getting a little more confusing, I think, to a certain extent. But going back to to the oldest days, 1899 or whatever, with Stratford versus Greensboro, Goldston's repeated it, Tier v. Jordan said it in 1950, that there's no question that citizens as taxpayers have the right to maintain an action to restrain the unlawful use of public funds to their injury. There's no question about that. I don't think Fuller changed that. I don't think Quorum changed that. Craig, nothing's changed that. That is our fundamental law. As Stratford said, there's no serious question whether a taxpayer has an equitable right to sue to prevent an illegal disposition of public funds. Otherwise, taxpayers would be, I think they say, they'd be liable to be plundered whenever irresponsible men got into government. So, that's been our law for well over 100 years, that the doors of the courthouse are open. The question is, how do you get there? How do you get into these doors? I think that the Craig case really clarified this when it said that, we've got a long-standing emphasis on ensuring that taxpayers have redress for every constitutional injury. In the absence of an adequate state remedy, one whose state constitutional rights have been abridged has a direct claim against our state under our Constitution. So the question then is, having said all that as preface, was this a constitutional violation? And we believe it clearly is under the Constitution, under Article 5, Section 2, subsection 1. And that article provides, power of taxation, the power of taxation shall be exercised in a just and equitable manner for public purposes only, and shall never be surrendered, suspended, or contracted away. And again, this goes back to exactly what Stratford v. Greensboro was talking about, that there's got to be a method to ensure that your funds are not unconstitutionally spent. And this has often been referred to as the public purpose requirement. And we believe this does create a right. We believe that this right is similar to the right in the red light camera cases that said it has to be spent in this way, can only be spent in this way. Now, we've also in our brief talked about two other sections, Article 5.2.7 and Article 5.7.2. That's not where we're alleging the right comes from. Those articles and sections, we believe, help prove our case that this was illegal. But that's not where the right comes from. The right comes from Section 5.2.1, which was cited in the complaint. So the next question is then, was this not a public purpose? And that's where the statute comes into play. GS 521, which is about 150 years old and entirely unchanged during that time. And it says that that it's unlawful to appropriate any public funds to the payment of counsel fees in an action to try the right to the title of the right to any state, county, or municipal office. And that comes from the Quo Warranto section, the Quo Warranto Act. And Quo Warranto is, as your honors know, I know you're all well acquainted with the briefs, is an old action, now it's statutory in North Carolina, that it's the only way to challenge a person's right or title to an office that they're sitting in. And it's a state action. It belongs to the state of North Carolina. So the only way that you can bring that action is getting permission from the Attorney General to bring the action. And frankly, that kind of explains, I think, one of the reasons why they have this prohibition on using public funds for this. If the state's bringing an action, because again, every municipality is a mere instrumentality of the state can say, we don't want you using tax dollars to fight the lawsuit that we brought. But whether or not the statute's a great idea is really irrelevant. The issue is, there it is. And the function of that statute, yes.
When the action sort of certified or approved by the Attorney General to be brought by a private party, I mean, it's as I understand it, it's pretty typical to say, yes, bring this action. We're not commenting on the merits. We're not necessarily putting the weight of the state behind the validity or the merits of this action. So so I guess the question is let me ask you, what was the basis of the dismissal of the underlying Quo Warranto action?
Well, the basis of the dismissal was that Rotrock took a dismissal. That was not dismissed by the court. He quit because it no longer served his purpose. He could have pursued it, or anyone else could have stepped in to take his place as relator. And frankly, I'm not sure he was entitled to dismiss it. Just like with qui tam actions, you usually have to get the government's approval to dismiss it so you don't have collusive things. But he dismissed it because it wasn't going to put him back on the town council. He still could have pursued it to say she shouldn't be on the town council because they didn't fill the seat correctly. But
So I guess my question becomes, how does, if just hypothetically, if someone were to bring just, an entirely frivolous action and just labeled it a quo warranto action, failed to, comply with sort of the statutory requirements in Chapter 1, does that preclude the use of public funds simply because they've labeled the action a quo warranto action, even though it was an entirely a meritless quo warranto
Well,
action?
I don't.
And I'm
think
not
it-
saying that's
I
necessarily
don't think it does, but not from the beginning. I think you'd have to go to the judge and bring some sort of motion. You'd bring a motion to dismiss this or to have it, a summary judgment motion, say, this isn't a quo warranto action. Something to say, for the court to decide. The litigants don't get to decide that it's not a quo warranto action. The court is going to say, this isn't a quo warranto action. First of all, if the Attorney General hasn't approved it, well, then that part's easy. Here's the steps you need to meet. You didn't need to meet it. But if, for example, a person got approval from the Attorney General and then what you get instead of a quo warranto action is like a breach of contract complaint or something, then, that's something you bring up with the trial court. You get it dismissed on that basis. You get the court to find that it was not a quo warranto action. Again, the parties don't get to decide it was a quo warranto action. And if anything, in this case, Judge Hall felt, in a prior act, he stated originally calling it the qui tam action, or the quo warranto action. But the fact that an action may be meritless, the statute doesn't say anything about except, you can't use public funds except if it's meritless. It doesn't say that. So, I think, again, the trial court would have a right to look at the case and examine it to determine, is this a challenge to this person's title to office? And if it's not, was it approved by the Attorney General, and is it a challenge to this person's title to office? And if it's not, then the judge could say, this is not a quo warranto action. And at that point, it'd be fine for a municipality to spend money on.
But if those determinations aren't made in the underlying quo warranto action, what authority in a subsequent collateral action would the trial court have to go back and revisit those determinations?
I don't think it would at this point. They didn't raise it in that case. If that was going to be an issue.
But it was voluntarily dismissed, is what you're telling me.
Well, right, but the defendants didn't raise that in that case. That wasn't, they didn't bring a motion saying this isn't a quo warranto action and we want the court to rule on that. They had a chance. Actually, not defendants. There was one defendant, Diane Laughlin. She didn't bring a motion saying, hey, this isn't a quo warranto action. That was her chance. If she wanted the town to pay for her defense, that's where she should have raised that issue. So yes, once she didn't do that, well, now it's not something that's open to debate. Or possibly it is. Possibly it's a matter for trial. Maybe that's a defense to our claim that they can come in and show that this wasn't a quo warranto. But not at 12b-6. Or I don't believe at 12b-6. I think if you look at that, if you look at the complaint on its face, the quo warranto complaint on its face, it's challenging her title to office. If it wasn't, then I think Your Honors on de novo review could go, well, on its face, it's not a quo warranto. It's not a quo warranto action. So, but again, their defenses were all matters that went to the merits. Whether it's collaterally estopped, things like that. And I'd also be clear that there's nothing magical about this. That if the legislature wanted to change this rule, they absolutely could. 521 is just the legislature saying this is a private purpose. But they have, it's a session law that's in the complaint. We also put it in memorandum of additional authority. But for example, they waived it for I think the Board of Labor or something like that. They have the ability to change this rule if they want. The not using these fees for quo warranto is not a constitutional thing. It's just that the statute says it's a private purpose. But they could change it. The legislature gets to determine what a private purpose is.
Well, the statute just says it's unlawful to appropriate
Well, correct.
the public funds for the payment of council fees in these actions. But how does that then, probably moving ahead in your argument, how does that square with Chapter 160A, 167 in
Yeah,
this case?
absolutely. Well, and I, as we lay out in our brief, I have trouble even grasping the 160A argument, frankly, because the language is very clear that, that 160A applies for suits that go to a person's acts. So when someone is sued in their capacity, something they did, then 167A kicks in, and the town can pay for that, because basically the town's being challenged. Whereas a quo warranto act does not challenge anything the person's done. It only challenges the fact that they are sitting there. They could be a sack of potatoes, and you can still challenge under a quo warranto act the fact that they have the office. And as we've cited, their arguments about that you're challenging their actions that they took, that's entirely contrary to North Carolina law. Because as a matter of law, and again, it's about 120, 150 years old, that anything the person did while they were in that office is still valid. You can't challenge their actions through a quo warranto action. And I think even if you were going to, you would have to have things in there, they voted this way, they voted that way, they were the majority here, this was the deciding vote. There's none of that in the quo warranto thing. It's just saying she's got it, she's sitting there, she's voting, which he needs to show that she has the title to the office. And again, the other things we talk about are, it says that you can use money for things under that chapter. Well, quo warranto is not under 160A. It is under Article 1. So it's not under that chapter. Again, you also have to go to the issue of, whether, because 521 is still sitting out there, the only way to get there is there has to have been a repeal by implication. And how do you get that? You have to find that these two cannot be reconciled. So you really have to start reading into 160A, 167A to create a conflict. And then you have to believe that the legislature intended to repeal 521. And again, when we go to the session law, we see they know how to repeal it when they want to. They know how to get around that statute when they want to. They didn't do it in 160A. They didn't say, for example, notwithstanding 521, blah, 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 you can use funds for this. There's absolutely nothing in that section that indicates or suggests that it was intended to apply to actions to challenge a person's right to.
But recognizing we're 12, in sort of this 12b6 world, nothing precludes the trial court from going back and looking at kind of the allegations of the underlying quo warranto complaint. I presumably it was referenced in the, but were there not allegations there that is it Ms. Laughlin was sort of undertaking actions and challenging some of the actions she was undertaking? And
No.
I know
Yes
you're into
and
your
no.
10 minutes.
Yeah, and that's fine, Your Honor. I'm here to answer questions. So that's half correct.
Okay.
There are allegations she was sitting in that chair voting. There is absolutely no allegation challenging any vote she took, any action she took. There's nothing in there that says that anything she did is void, illegal, improper, doesn't count. It's just she's sitting in the seat, And again, how do you allege? It's just stating the fact. I had the seat. I don't. She's got the seat. She's doing what you do in the seat. I mean, that's all it alleges. And he has to show that she's got the seat. That's an inherent part of if she doesn't have the seat, then why are you challenging it? So it's half yes, half no. And that is the fundamental thing. I agree. If he started like saying things, for example, like this bond referendum passed because she voted for it, well, that's not a quo warranto. If he's trying to challenge things she's done in this, or if he starts saying together they've done X, Y, and Z, and that was wrongful, that's not a quo warranto action. Then 160A, 167A would kick in, but he's not challenging any acts she took. The only thing he's challenging is the fact that she's sitting in the chair to begin with. That's why that statute doesn't apply. If your honors have no other questions at this moment, I will reserve the remainder of my time. Thank you, your honors.
Thank you. We'll hear from the appellees. Or appellees, yes, depending on.
May it please the court, my name is Gray Wilson with the Nelson Mullins firm from the Forsyth Bar. I represent all the defendant appellees except my law firm, and would reserve at least 5 minutes for co-counsel to address the disgorgement issue. I think I would open by telling this court that I believe I'm the only attorney or person in this room that has traveled with all 5 of the lawsuits leading up to this one, and the various plaintiffs have lost all 5 of them at the trial court level. 2 of them were affirmed on appeal by this court, and all of the claims are derived from the removal of Todd Roetruck from the town council for the simple reason he never lived in Summerfield. And the town and the defendants in this case had nothing to do with that. A private citizen took a complaint to the Board of Elections, and they found that he couldn't be a council member there since he didn't live there, and that was later taken to the Superior Court and then affirmed by this court, which did wax his ability to stay or regain the seat that he was not entitled to hold. That was an ipso facto matter that once they found he didn't live there, nobody had to do anything. He was defrocked as a matter of law. Our defendants had nothing to do with that. Before I address what I think are 2 substantive issues in the case, I would just like to point out one thing on pages 9 and 10 of our appellate brief. We simply pointed out that there were matters that had not been preserved by plaintiffs in the opening brief. There were 4 of those. I think the most important one is the statute of limitations, which wasn't even addressed at all. And a reply brief, certainly under the Wilson against Pershing case.
So I'll ask you the same question. I mean, what do you contend was the basis of the trial court's 12B6 dismissal here?
Oh, there was a cornucopia of grounds for the trial court's dismissal: the statute of limitations, collateral estoppel, the fact that it was not a valid quo warranto lawsuit, and the court also may have granted a dismissal based on lack of standing. But I think that the 12B6, although the facts and factual findings and conclusions aren't required to be in that order, these matters that I've mentioned were briefed and addressed before the trial court. So, and I was going to address, I think, 2 of those substantively. And first, I would tell the court, because you asked the question in a different way, that the quo warranto lawsuit was, in fact, a sham. This was the 3rd lawsuit in the series. The first lawsuit that was filed against the town by Mr. Roetruck was a mandamus action. He wanted his seat back after the Board of Elections had denied it. And that, in that case, we filed a motion to dismiss. It was granted by the trial court with prejudice. There was no appeal. So he couldn't get his seat back by way of mandamus. The second lawsuit was really the Board of Elections lawsuit. I've already mentioned what happened to that. Then you get to this 3rd lawsuit. And this is an effort by the same gentleman to try to reclaim this seat, at least by stripping Ms. Laughlin of that office. That's, in fact, the second mandamus lawsuit, if you look at the prayer for relief. So the first response I have is, let's say it's a valid quo warranto action. He's asked for a mandamus. Can the town not hire counsel to defend a mandamus action aside from any decision about whether or not the quo warranto is even a valid claim? It was not a valid claim. And the the Attorney General who signed off on that lawsuit was hoodwinked by the plaintiffs who failed to reveal the 2 prior lawsuits. You ask a question about whether or not, if the state signed off, you know, it mattered if it was meritless or not. Well, here, it was by subterfuge signed off by the state. And you have the affidavit of the Chief Deputy Attorney General in the file, Alexander Peters, in the record. So this was actually Mr. Roetruck's 3rd effort to relitigate the 2 prior cases that had already stripped him of his seat on the town council.
But the language of 1-521 is pretty stark. I mean, it's pretty direct, and I mean, there's no sort of conditional language there. It's just very much, it is unlawful to appropriate any public funds to the payment of council fees in any such action. How do you address sort of the plain language of the statute that seems very of broad application?
Well, I suppose then anyone could file any kind of claim if you got the state hoodwinked into doing what you said, which would just be to sign off on it, and it would be an absolute triumph of form over substance. I don't know how else to address it, but that doesn't end the inquiry about defects in the quo warranto action, which I'm going to address as well.
Well, and sort of circling back to another question, you said, you know, there was with the prior mandamus action and would the council be permitted to hire or to use public funds to pay attorneys to defend a mandamus action. How would it work if these claims were sort of joined together? If there was a claim for mandamus, a quo warranto claim, I don't know, a fraud claim, all joined. I mean, how does would you say, okay, well, you know, we're not taking funds for the quo warranto action, but we are paying, you know, the attorneys with public funds for these other two claims?
And I can only respond to that with a rhetorical question, which is how in the world would you ever parse that? I mean, can you imagine?
I guess that's my question too.
Yeah, I don't know how, and I think that would reduce really down to absurdity the notion that the defense of this lawsuit by the town of this lady who was in fact attacked in the pleading would be improper. And again, you know, he's not just asking that she be defrocked and removed. He's asking in the complaint, put me back in. And this is the third time. That's actually the second time it's been done by way of mandamus. The third time, of course, was the effort collaterally through the Board of Elections.
So what are sort of again, in this 12b6 world, what are the allegations in the complaint or lack of allegations in the complaint that establish as a matter of law at this early stage in the litigation that this was not a valid quo warranto action?
Well, that he is, in addition to trying to establish that this person is entitled to hold the office, that he's attacking her with regard to her conduct in office and attempting to reclaim the seat for himself. I'll read to you quotes from it, that he was elected a position which lawfully and unlawfully holds, which was never vacant, that he remains a member of the council, that he's the rightful holder of the seat, these are quotes, and presently entitled to occupy the seat to which he was elected. And the complaint concludes with the demand that Row Truck, the plaintiff, quote, be restored to the council position to which he was elected by way of mandamus. So again, I think the sham nature of this action is established by that pleading. I think it's also established by the fact that it's a mandamus claim, third round. And the second point to that is that makes it a sham is, and he also says that the quo warranto lawsuit was only, this is in the complaint, is primarily to challenge her title to office. And paragraph 48 claims the lawsuit, quote, did not challenge any act by Laughlin in her official capacity, which is simply not true. Because at the hearing before the trial court, the plaintiff's argument was that Laughlin was not entitled to hold the position, even if it determined that Row Truck was not either. Now, those allegations, they dovetail with the argument that's already been mentioned about GS 160A-167A. And here's a second ground. It bars the faux quo warranto lawsuit for attacking defendant Laughlin in her official and individual capacity for her conduct in sitting on the council seat and voting on matters unrelated to the validity of Mr. Row Truck's alleged quo warranto claim. I cannot improve on Judge Hall's reasoning in the dismissal of the fourth lawsuit. He did stay this quo warranto action. It was just mentioned that we didn't do anything to try to challenge the validity of it. We did. It's in the record. We filed a motion to dismiss or to continue or to stay the matter, and it was granted by Judge Hall. And in doing so, he looked at the prior actions I have pointed the court to here today, and he made the observation that it was concerning that there might have been issues that were disposed of in these prior matters that made this alleged quo warranto action inappropriate. But he stayed the matter then because the Board of Elections decision that was affirmed by the Superior Court was on appeal. You asked, well, why was the quo warranto action dismissed? It was dismissed because this court affirmed the Board of Elections opinion. That's why he dropped the lawsuit. I would say that's a pretty good determination. It doesn't need to be done by, you know, some lawyer. I think it was done by the court, which prompted that dismissal. So Judge Hall's further opinion in the fourth lawsuit when he dismissed the case, I can't improve on the logic of his argument, and that was this gentleman has now taken 2 runs at this, and at some point in time there has to be a recognition that he can't continue to use various pleading forms to try to reclaim his position on the town council. And Judge Hall also made the comment that the 2 statutes, 1-521 and 160A, that those are necessarily inconsistent and irreconcilable. He pointed out in his ruling, very appropriately, better than I can do it here today, that they're not, and that in this situation it was very appropriate for the town to step in and defend her. And then he made a pretty important point. He said, and I've said this for all 5 lawsuits, because these lawsuits before were won, so the town was correct. It was right in its position. And that's our position here today.
So is it kind of your position that the prior mandamus lawsuits had preclusive effect on the quo warranto action, and then in turn preclusive effect on this action in determining whether it was a valid quo warranto action?
Yes, sir. I would address next the statute of limitations, which was argued and briefed. Again, it's incorrectly cited in the reply brief, but there's no mention of it in the opening brief from the plaintiffs. But in our response, we pointed out that this quo warranto suit, for which our legal fees were challenged, was filed on January 3, 2019. 5 days later is when the council approved the hiring of this law firm. I don't know when the engagement letter was signed. There's some reference in the complaint to when and how we were paid, but I know this, and it's in the record around page 78 or 79, and page 79, and that is when the matter came on for hearing in the quo warranto action with regard to our motion to dismiss or stay. The court noticed, it cites my name and says I attended the hearing. I think at that point in time, the court could conclude that there was a contract with my law firm and that I was actively defending this case in order to trigger any statute of limitations inquiry, and that's almost 3 years before this lawsuit was filed. It's way outside the statute under any stretch. So we had a contract more than 2 years before this 5th suit was filed, and GS 1-531 refers to a contract, something arising out of a contract with relation to a governmental entity.
But again, kind of pulling this back to this posture, so the 12b6 posture, rather than a summary judgment posture where you'd have the opportunity to forecast evidence and see if there was a genuine issue of material fact, and certainly you could raise a statute of limitations, well, not raise it, but argue the statute of limitations defense at the summary judgment. I mean, are there not questions of fact regarding the nature of the attorney-client relationship, when, whether it was a continuing contract, you've got, I guess with the municipality, you've got sort of pre-audit rules and everything else in terms of, what the budgetary appropriations for the hiring outside counsel, that kind of thing.
I recall the continuing wrong argument was pitched somewhere in one of the cases we looked at here. I can't imagine that it would apply here. I really can't grasp if there could be any legitimate contention that the contract, that's what the lawsuit, that's what the statute says, arising out of the contract, that the contract didn't exist at the time that I was in court arguing the threshold motion with regard to that case, almost 3 years before this lawsuit was brought. But I'm impressed that the court would think I would show up without being paid or having a contract in that regard. So again, it doesn't matter how my law firm was invoiced or how it was paid. The claim accrues, if at all, we say when the firm was hired on January 8, 2019. But if not, then by February 11, 2019, when we are in court arguing the initial threshold motions, which did include one to dismiss the quo warranto action as invalid. And of course, we would be advancing the same arguments we did here today had a stay not been granted, which was judicious because the Board of Elections affirmed, and then the case is gone. And that case, I say at that point, becomes dispositive. It's not up to a lawyer. Really, I can't imagine anybody better qualified to make the determination that that matter is not valid when they dismissed it, as Mr. Rotruck did. And that dismissal became with prejudice, again, within the next year. I don't intend to address arguments about standing unless the court wants to ask me about them, and I'm happy to tell you why. You mentioned whether or not this court, and I think you have a concession that this court could affirm on the basis of any law that would be applicable. And here you have a 12b6 order, and I think the court has the option to go ahead and affirm on that basis. The reason I'm not interested in having a dismissal without prejudice is at some point these cases and these parties, Rotruck and his cronies, these matters have to judicially die. If you dismiss for lack of jurisdiction, we'll have another lawsuit. We'll have a sixth lawsuit now. And I guess there'll be another question about who can defend that matter. You know, the determination has to be made when you're facing subject matter jurisdiction that it can't always, as suggested by the United Daughters of the Confederacy case, it can't always be a dismissal without prejudice. If that's the case, then there can never be an end to any case. You dismiss it for lack of standing, you refile it. It gets dismissed, you refile. I know that's absurd because at some point the court would have to intervene and say, whether there's no jurisdiction or not, this can't go on. Collateral estoppel has to be asserted at some point. The Supreme Court of this state at some time is going to need to flesh that issue out a little more than it has been. But in this case,
I guess that raises, the question. I mean, if you have a case where, you know, taxpayer standing is alleged and it goes through to summary judgment and it's determined that the taxpayer is in fact not a taxpayer, I mean, that would seem to have some preclusive effect on a subsequent decision or in a subsequent case.
fine, but if it has an effect and then it's refiled and there's no subject matter jurisdiction, then it's dismissed again, and that's without prejudice until there's some determination that that can't really be the case. I have one suggestion in that regard. The Cox v. Hayworth case, the United Daughters of the Confederacy case was decided after the dismissal was entered in this case. And that being the case, if one wanted to dismiss here or felt compelled to dismiss for lack of subject matter jurisdiction, then they would be applied retroactively to the trial court's decision. And the Cox case, I think, points out that retroactivity in that regard should never be applied if it might prejudice one of the parties. And I would say lawsuit number 6 would prejudice the parties that I've been privileged to represent for the last 5 years. If there's any question about that, I know that we'd be happy to do supplemental briefing, but, you know, I'm almost at the point to say if the inclination is to go on and bounce this case so that the 6th one can be refiled, I would just assume the court find standing and affirm the dismissal pursuant to Rule 12b-6, or just affirm the ruling pursuant to Rule 12b-6 for any law applicable.
But of course, you also can't really consent to subject matter jurisdiction.
You're right. I mean, it really is. It's a rebus, and I don't know how to explain it any better. But you know, if you want to latch on to the Fearington or the Fuller or the Goldston cases, I'm not going to stand up here and argue that you do that because I think it prejudices my client to do that. And I think that's the key
Who
to
is your client?
the clients.
Who are your clients? Well, let me ask you that question a different way. Who are the parties to the quo warranto action?
Well, that was just, the plaintiff was Row Truck and the defendant was Miss Laughlin. And she was the lady who, after the Superior Court, I believe, affirmed that he couldn't hold office, the council went on at that point and elected her to that seat, which she held for some minor period of time.
But that's what's at issue in this case is the purported fees paid in defense of the quo warranto action. That's why I asked who the parties were. As I understand it, Mr. Rotruck obviously had been involved in 2 cases prior that didn't turn out well for him. But in this one, the quo warranto action, he was a relator on behalf of the state, not in his individual capacity. It's important for me to understand who the parties are that led up to the lawsuit that we are and who you were representing at the time.
Okay. And my representation was just Miss Laughlin at that alleged quo warranto lawsuit. So again, you know, we're at the 5th case here. We've sort of run through those. I'm sure the court's familiar with the history of the matter, but I think that we need to recognize at some point there are cases that need to judicially die, and I think we've reached that point with regard to these 5 cases. It's been my privilege to serve on. If you have no other questions, I'll turn the matter over to co-counsel.
Thank you.
Thank you.
May it please the court, my name is Alan Duncan from the Guilford County Bar. We find ourselves in a somewhat odd posture in this case with respect to the Nelson Mullins law firm who I represent in this matter, given that there was a filing to the effect that there would be a withdrawal of the appeal which would reinstate the dismissal with prejudice of the Nelson Mullins firm at the trial court level. We are in agreement on that, and obviously the court will now decide what to do because there's not a procedural rule the same way there would be if we were at a trial court level, and I assume the court will deal with that appropriately. So I don't want to take a lot of time arguing the one area that would affect the law firm, which is disgorgement. I think I can do it in less than 10 sentences. If you want to hear those 10 sentences, I will be glad to proceed.
Would be glad to.
Thank you. As an opening point, the law is clear that disgorgement is not a claim. It is an equitable remedy for contract or quasi-contract claims. Courts dismiss disgorgement when it is pled as a claim, and it should be dismissed here. As a remedy, disgorgement should be dismissed because plaintiffs lack the ability to pursue such a claim under North Carolina law. There are at page 12 of our brief, there's references made to the Potter versus Hylam Labs case, which talks about what restitution does in terms of measuring damages. There are cites to business court case. There are multiple business court cases to say this. I realize that is not binding precedent before this court. There are also cases from the Western District and Eastern District. Again, reiterate, this is North Carolina law. We have not been able to find any case that suggests that disgorgement, in fact, does constitute anything other than a remedy as opposed to a claim. In this situation, plaintiffs, in any event, have not stated any claim for which that relief could be appropriate. Plaintiffs do not allege that the firm committed any misconduct under the contract or breached the contract, yet they suggest disgorgement as a remedy. In fact, it's undisputed that the firm has been successful at every turn with respect to its representation of the town of Summerfield and or any of its individual council members for which it has been called upon to represent as a result of this continuing saga through this, the 5th lawsuit.
Does kind of beg the question, though, what is, you know, what is the remedy for an unlawful use of taxpayer funds or public funds for a private purpose in terms of, you know, sort of clawing back those those funds, I mean, is that a potential remedy against essentially a third party, third private party here, or is it, or is the remedy simply, going against the commissioners on their bonds, I guess, I don't know.
There's certainly no legal precedent to suggest that someone who carries out, a third party who carries out a contract appropriately and with, in good faith and with success would be subject to having the funds recovered in that manner. So I think that's as far as I feel comfortable in going, is just sticking with precedent.
Yeah, thank you.
Thank you.
Thank you, Your Honors. As a Marine, I did a couple tours in Iraq, and at that time we were flying helicopters that were 60 years old. And our only defenses against missiles were what we called chaff cannons, which blow out thousands of little pieces of aluminum and flares that try to distract missiles from finding the helicopter. And all this talk about roadrock is just chaff and flares, because this case is not about whether Todd Roadrock should be on the town council. It's about whether or not Diane Laughlin could have public funds used to pay for her to hold on to her seat. Ultimately, I do want to comment, because they do this so
But
much
if those
in their...
prior
in their-
lawsuits
Yes.
had nothing to do with Quo Warranto, if they were, if this was truly a mandamus action, is it your position that public funds could not be used in the defense of that case?
Well, I don't know that he used mandamus. I think, Mr. Wilson keeps using mandamus because he feels this is a mandamus. I don't recall that being at issue in either.
The term mandamus is in the prayer for relief.
That could be, but I don't think and I'll be honest, Mr. Wilson admittedly knows much more about the Todd Roadrock cases than I do, because generally they were irrelevant to my case. I don't know Todd Roadrock, never met him, and this thing about them being cronies, if we had any control over Todd Roadrock, he never would have dismissed his action. We would have had him continue it with regard to Diane Laughlin. So it's just insulting to have these crony things thrown out, hoodwinking, things like that. Again, if that third action, the Quo Warranto action, reading it, because again, this is 12b-6, if looking at that complaint for Quo Warranto, it doesn't have the AG's approval, or it's not a challenge to her office, well, then I think the judge could have said, hey, your thing fundamentally fails because this wasn't a Quo Warranto action, so 521 doesn't apply. So, and I believe your honors could do that also, because again, it's de novo review. But even though Mr. Wilson keeps saying that Roadrock challenged her actions in office, he's never pointed to an allegation in the Quo Warranto complaint where Roadrock supposedly did that. What did he challenge? When your honors look at it, you'll see no. All he says is she's in the seat doing the job. And I don't want to get into all of that case, but there was actually an interesting issue, because there's a statute that says once you're deemed not eligible, you're basically, the seat's vacant. But it doesn't talk about what happens when he appeals it. Is it stayed during appeal? And that case was being appealed. So he might have been able to win his Quo Warranto. I have no idea. And again, I don't care. It doesn't matter to this case. Was it or was it not a Quo Warranto action? With regard to the statute of limitations, again, we're not pursuing the second or third claims, and I believe those are the only claims where the 2-year limitation could even conceivably be applied. Our court in Hamlet made it very clear that for a declaration concerning unconstitutional spending, that's the 3-year statute of limitations under GS 152-2. And that's all we have left. We're just, seeking to have a declaration that this was illegal spending. And even beyond that, though, again, this is 12b-6. And this is one of the problems with the court's jurisprudence, that you don't have to have findings on 12b-6s, and saying 12b-1, you can have these 12b-1 defenses, but they can be alleged under 12b-6. So you end up with these things that really should have findings, and statute of limitations requires findings. You need to know what is the statute that was being applied, and when do you believe it commenced. And that is nowhere in the findings, and it's also nowhere in the complaint, because 521 doesn't say you can't make contracts. It says you can't spend money. The date of the contract is entirely irrelevant to this case. The things that that matter are when were checks being sent? When was the money being spent? And it's not in the complaint because, frankly, we don't know when those dates happen. They could still be happening. Probably not, but it's conceivable. So on a 12b-6, the statute of limitations just should not be a defense. This whole thing, though, about it being about the Quo Warranto being a sham lawsuit, Mr. Wilson talks about hoodwinked, and the AG was, was hoodwinked and it was subterfuge. Again, this is 12b-6. This evidence should not have been considered, period, and I don't think the trial court did. An affidavit from the AG saying, and he doesn't say he was hoodwinked, he said, I didn't know about that. He didn't say I wouldn't have granted it if I had known about it, but that's not 12b-6. But it also points out if they thought there was a big problem, why not go to the AG at the time and say, hey, were you aware of these things? Get the AG, because it's the AG's lawsuit. The AG could step in and go, yeah, we're dismissing this action. And I think, that goes to one of your questions, Your Honor, about, how can you end one of these things? Well, bring it to the AG. It's the AG's action. If it's truly not a quo warranto, then the AG can terminate it. They didn't do those things. But in any event, this is 12b-6. The AG's affidavit can't be concerned. One of the things they talk about, and Judge Carpenter, I think you kind of touched on it, was, Mr. Wilson goes, well, this is a mandamus action. Can't the town hire an attorney to defend a mandamus action? The town was not a party to that action. So, the town had no right at that point, procedural posture, to do anything. But going back to your question
Well,
again,
unless
Judge,
168,
maybe,
167.
If it's not a,
but, well, again, I think, going to your question, Your Honor, I think the town could have moved to intervene. If they really believed all these things, move to intervene. And at that point in time, going to your thing about how do you parse it out, well, at that point, the town's thing, we're paying our attorney to intervene because we want this thing quashed. I think that would be permissible. They didn't do that. Instead, taxpayers went and told the town council, you're not allowed to do this. There's a statute that says it. And the town attorney at the time said, that's ludicrous, that's ridiculous, and just like brushed them aside, and they did it anyways. And that's what this case is about. The reason we've dropped claims 2 and 3 is because this isn't about punitive action. We're not trying to punish the town council members. We're trying to see that this illegality doesn't happen again. So we're trying to get a declaration to tell them, look, you can't do this. Don't do it again. And that's why we do believe that Goldston's probably right. If the trial court or this court says you're not allowed to spend public funds on quo warranto actions, then when it happens again, then taxpayers can go to court, seek a temporary restraining order, seek a preliminary injunction, and stop it to protect their rights as Goldston and State v. Greensboro and all those others. I see I have very limited time, and I've been doing all the talking. Do any of your honors have any questions?
if it's not a valid quo warranto action, isn't it just an action against the commission member in her official capacity holding that office? And if so, isn't Mr. Wilson right that the town can spend money to defend that?
I agree. If your honors look at that quo warranto complaint and you find that it's not truly a quo warranto complaint, then on 12b-6, we failed to state an element. But I think the clearest distinction is that that was a quo warranto action, and that's why 521 applies. But in this action, where we have challenged what they did as council members, that's why 160A, 167A applies. But yes, I believe your honors get to look at the quo warranto complaint or the quo warranto complaint, and if you find it's not a quo warranto complaint, then that'd be a 12b-6 grounds for dismissal.
So it's not about failing to state an element here. It's asking for, assuming you've stated all the elements, if he asks for something, if he states an element for a tort, but wants relief for something else, he stated all the elements. He just asked for something he can't get under the element stated. And I think that's the point that Mr. Wilson is making here, that he stated elements for something, but that's not what he's asking for.
Well, that's what he's arguing, but I don't think that's true. I think you look at the complaint, that's not accurate. He was doing what a quo warranto does. The first thing a quo warranto does is it challenges an office holder's right to title. That's the quo warranto. Todd Rotrock didn't even have to put anything in Todd Rotrock about there. If he had just said, she's not supposed to be in there, that's a quo warranto action. Now, a quo warranto action can also say, I'm the person who's supposed to be there. So, and then the court can determine you are the person that's supposed to be there, but in every quo warranto action, no matter what, the court has to determine whether the office holder gets to keep that office. So you know, I think the better argument would have been if he had gotten permission for a quo warranto, but then he comes in with, and you see a lot of these pro se litigants who just start slamming, they did this, and they did this, and they did this, and they did this. Well, and I want them to stop building that, you know, that bus station or whatever. That wouldn't be a quo warranto action. And then they'd be okay in spending money on that. But again, they'd still have to prove it wasn't a quo warranto action. But I believe, because again, it's 12b-6, and that case is over, you just look at the complaint at this point. All these extraneous factors that you would bring in are not 12b-6. It's just a simple question of, was it, you know, and again, his arguments are about why Rotrock was going to lose. That's the merits. That's not the nature of the claim. And I believe that I may be over.
We'll give you just a moment to wrap up, if you'd like.
That's really it, Your Honors. You have our briefs. If there are any other questions, I'd love to answer them. I really appreciate your time here today for the opportunity to discuss this case. And thank you.
Thank you. And thank you, counsel, for your excellent arguments. And obviously, very able advocacy for both sides. The case is submitted, and I believe we're ready to adjourn.
All rise. This session of the North Carolina Court of Appeals is adjourned.